Docter S Chelvan joins me here in the studio. He is Head of Immigration and Public Law at 33 Bedford Road, Chambers, and also a Professor at Southampton Law School. Thank you very much indeed for joining me.
Good afternoon, thank you.
Can we start? Very few of us had the chance to read the entire judgment. Would you be able, for the listeners, to précis what it is that judgment said and on what point of fact and law the 5 judges arrived at their decision?
Well, I was grateful as a lawyer that the judgment was a much shorter 56-page judgment rather than the 142 pages of the Divisional Court and the 165 pages of the Court of Appeal. But there are 2 issues. It's a balanced judgment. And as a lawyer, it was wonderful to see the British Constitution at its finest, where we had British judges in a British court applying British law. So this is all about taking back control. And the first issue which the Home Secretary hence why the appeal was dismissed, is the issue that is there substantial grounds to believing that when you send a refugee to Rwanda, there's a real risk of refoulement. That means returning back to their country of origin, not Rwanda, country of origin, where they'd face a real risk of Article 3 harm, ill treatment. Now, it's important to know that the judges were fully aware that the spotlight would be on the European Convention of Human Rights, and they were made it very clear that we're also party to the 1951 Refugee Convention and 1967 Protocol, Article 33, the non-refoulement principle, the UN Convention Against Torture, and there's domestic legislation, including the 1993 Act, the 2002 Act, and the 2004 Act. So it's very important that the domestic framework within the way the court looked at it, and they made it quite clear that before the ink was dry, following Dame Priti Patel's signature on the Memorandum of Understanding in April 2022, we have, on the 19th of April 2022, the Rwandan government sending a Syrian national back to Syria via Turkey. So they'd already breached the principles of safety in relation to Rwanda. They also held quite clearly that on the evidence, and United Nations High Commission of Refugees was pivotal in relation to the fact-finding exercise. And they were able to show around 100 cases of refoulement, or people being returned back to their country of origin, even at the airport, that's one route, or clandestinely via Uganda. And UNHCR even had to step in when some Eritrean nationals were being sent back to Eritrea via Kenya, and they only stopped their return because they found them in Kenya. But when we look at the statistics, 100% refusal rate for refugees from Afghanistan, Syria, and Yemen between 2020 and 2022, we're comparing contrast with the UK figures, we're talking about 70% for Afghanistan, 90-odd% for Syria, and 40% for Yemen. So what the Supreme Court was saying, which is black, and this is why the government is now trying to say black is white, is that Rwanda cannot be trusted to comply with international treaty obligations. It looked at the Israel-Rwanda plan, 2013 to 2018. Israeli Supreme Court also found that there was a real risk of people being returned. And the Home Secretary had not attached sufficient weight to that evidence. So importantly, the government's principle was we have the expertise and experience to deal with these sort of agreements. Courts should not come into the realm. They relied on the Shimima Begum case for that. And the Supreme Court, paragraphs 56 and 57, boring lawyer here, said no, anything which looks at the issues of human rights violations, the court can review when it comes to policy considerations. So that's why the government lost. But importantly, on the other side, hence why it's an objective, balanced judgment, is that one of the refugee claimants said, well, look, do we still have retained EU law under the Procedures Directive to say that you cannot return any individual to a third country where there is no connection? Because none of the claimants had any connection to Rwanda, and the Supreme Court said no, since the 2020 Act, the 2005 Procedures Directive, which hasn't been incorporated into domestic legislation, is no longer part of UK law. So at the divisional court level, the Home Secretary did not appeal the judgment, which said that all of the claimants had to have their individual decisions re-decided because the policy hadn't been properly determined. But importantly, the Home Secretary, through her lawyers, through the court procedure, has got a clear indication, and this is why parliamentarians must read the judgment, that when Suella Braverman in her 5 points, the first point is...
Hang on, before we get on to that.
Okay, so the Supreme Court said quite clearly that Rwanda is not safe, not even in relation to the evidence at the time, but shortly after the memorandum understanding in relation to the evidence before there. UNHCR must have sufficient great weight attached to its evidence, and therefore you cannot send to Rwanda.
Okay, so the court finds that there is a real and substantial risk that if the policy goes ahead, those asylum seekers that would, in theory, be sent to Rwanda, there is a risk that they could be repatriated either back to the country that they fled from or an unsafe...
primarily refoulement is back to the country of origin.
So what we now have is the government saying, well, actually, we're going to pursue this policy anyway. And there are two routes that we're going to use. One is a new treaty with Rwanda that will make it safer and make sure that all of the concerns raised by the Supreme Court and the United Nations are addressed. And then secondly, an emergency legislation that will establish Rwanda as a safe country. What are your thoughts on that, on those two routes?
Well, let's go through let's take the latter issue first. Under Schedule 1 of the Illegal Migration Act 2023, in the alphabet soup of countries which are listed in relation to safe countries, Rwanda appears as number 48. It isn't yet in force, and part of the parliamentary debates, and I'll declare the fact that I had discussions with Lord Edison across bench in relation to both the illegal migration bill and the earlier bill, is that they gave an undertaking that they wouldn't enforce Rwanda pending what happened with the Supreme Court litigation. Clearly, they've lost there. But importantly, how can you legislate for a country you can't trust? You can't. We've already spent £140 million, all the money we've spent in relation to litigation. And we know, and I know that politicians have gone on the airwaves saying, well, the majority of small boats refugees are economic migrants. Now, the Office of National Statistics and other bodies have said, well, where's the evidence of that? Refugee Council at the end of January 2023 published a report looking at the demographics of those across the boats and said that 80 to 90% are genuine refugees. In the past 2 weeks, a gay South African client of mine and a trans woman from Yemen, without even an interview, the second case, and just after interviewing the first case, have been granted asylum. We know that the majority of people who come to the UK to apply for asylum are either genuine refugees or granted some sort of humanitarian protection.
Understood. Let's just move over to that second point. This idea of a treaty strikes me as frankly impractical, because to address all of the issues that were raised by the Supreme Court justices would take years and years and years.
Well, I'm not a politician. I'm just a jobbing lawyer. And we've got the check and balances in relation to the courts, and we know with the Abakatada, memorandums of assurances regarding him and regarding Jordan with respect to him not being tortured.
Okay.
And that went before the courts as well. They're running out of time, and to be able to push through legislation, to be able to, you want me to address the government proposals or rather Suella Braverman's proposals at this stage?
Yes, she's gone. But we're going to come back onto the final thing about courts. Just
okay.
Talk to me about this idea that you can form a treaty between the UK and Rwanda that would, in a very short space of time, make it a safe country, reform their processes to the point where actually, were the policy to be tested again, the justices would find in favour of the government.
Well, the government situation at the moment, and this is very important because the European Convention of Human Rights and the Good Friday Agreement, is that they don't feel that they need to leave the European Convention of Human Rights. And that's very important because, of course, if the legislation is there and it's not giving an opt-out, then there could be declarations of incompatibility which will go to the courts again. So the treaty would have to come through parliamentary approval. So it would have to be an act of parliament. Now, we know that the House of Lords very much mobilised against the previous acts. We'll have to see the checks and balances there. If they reject the bill, then the government will have to wait a minimum of 12 months to invoke the Parliamentary Act to push the legislation back through, and they don't have time. But importantly, I don't think this is a real, Suella Braverman said that, the Rwanda plan was never going to work. This new plan is never going to work. It's not going to be first of all, if it gets passed through parliamentary scrutiny, it's going to come before the courts as well, because it's not a foreign court which will be stopping the removals anymore. because British judges have the power to stop the removal of an individual if there's a real risk of Article 3. And now that the Supreme Court has looked at the evidence and provided the starting point in relation to why Rwanda cannot be trusted, it will be British judges who will be enforcing, we call them injunctions, prohibitions in relation to the removal to Rwanda, to be able to examine the claim here. So this is a party political act to try and muster the votes for the election. I cannot see it really happening, and we know quite clearly that Rwanda is not safe. That is not taking into consideration the evidence we had in May 2018 of 12 Congolese refugees being shot by the Rwandan authorities when they protested against a 25% food cut in May 2018. 66 were arrested. This is irrespective of the fact that we know that if you're a political dissident in Rwanda, there's a real risk of torture and ill treatment. This is irrespective of the fact that the Foreign and Commonwealth Office, in their travel advice for Rwanda, have said since April 2022, when I looked at the advice, it's the same advice last night when I looked on the webpage, is that lesbian, gay and bisexual, transgender people have discrimination and abuse by the local authorities. So Rwanda is not safe, will not be safe in relation to any sort of deal, and it's just filibustering in relation to trying to get a political motive complete.
I strongly suspect they're going to carry on stringing it out until next general election because, of course, it is red meat for this government. Docter S Chelvan, Head of Immigration and Public Law at 33 Bedford Road, Chambers, and Adjunct Professor at Southampton Law School. Thank you very much indeed.